Ladies and gentlemen, it's a pleasure to welcome you back to the third and last panel of our conference, Contemporary Literacy on Anti-Corruption, co-organized with the Rule of Law Anti-Corruption Center, ROLAC, and UNITAR. I'm Ana Lucia Jacome, Senior Project Leader, and I have the pleasure to join you today as moderator. Same as yesterday, our distinguished speakers will be taking the floor, followed by additional time for replies to the audience. And we will try to do at least 2 or 3 rounds. We warmly invite you all to share questions or comments by the Zoom chat. We are going to focus today on further cooperation. We have the pleasure to receiving now Dr. Kanade. Dr. Kanade, who is the academic coordinator, head of the Department of International Law and director of the Human Rights Center at the University for Peace. Dr. Kanade, please, you have the floor.
Thank you very much. Dear colleagues, dear participants, it's my great pleasure to be here on the panel today. I've been asked to share my thoughts on the role of international cooperation to foster action on anti-corruption and its linkages with other fields, including sustainable development and human rights, and the related opportunities and challenges. Now, the United Nations Convention Against Corruption, which is a widely ratified instrument with 189 parties, including 181 states parties. The edifice of the convention in investigating and prosecuting acts of corruption and in recovery and return of stolen assets and illicit financial UNCTAD estimates that Africa alone is losing an estimated $87 billion annually through illicit financial flows. The Convention Against Corruption establishes a wide range of obligations on states to ensure international cooperation because realization of the anti-corruption objectives are otherwise impossible based only on individual state actions. Indeed, one of the main purposes of the convention is to promote, facilitate, and support international cooperation and assistance in the prevention of and fight against corruption, including in asset recovery. The convention stipulates that the return of assets is a fundamental principle of the convention, and states parties shall afford one another the widest measure of cooperation and assistance in this regard. The convention also imposes a number of obligations concerning asset restraint and confiscation on states that receive requests for international cooperation from states where the proceeds of corruption originated. Again, in quotes, widest measure of mutual legal assistance in investigations, prosecutions, and judicial proceedings in relation to the offenses covered by the convention are also required. Similarly, widest measure of technical assistance based on capacities of states is also envisaged under the convention. Now, international cooperation for addressing corruption, however, also needs to be situated in the context of larger global imperatives, especially the realization of sustainable development and the realization of human rights. Let me address these sequentially. The 2030 Agenda for Sustainable Development that was adopted by the United Nations General Assembly in 2015 acknowledges the indispensability of addressing corruption, including through good governance, if we are to realize sustainable development. In particular, it is addressed in SDG 16. Target 16.3 requires promotion of the rule of law at the national and international levels. Under Target 16.4, states have committed by 2030 to significantly reduce illicit financial flows, strengthen the recovery and return of stolen assets, and combat all forms of organized crime. Target 16.5 requires states to substantially reduce corruption and bribery in all its forms. Finally, Target 16.6 commits states to develop effective, accountable, and transparent institutions at all levels. Now, the 2030 Agenda acknowledges that states, especially the developing ones, cannot achieve all of this on their own. Indeed, the success of the 2030 Agenda is predicated upon the building of a global partnership for development and strengthening what are referred to in the agenda as the means of implementing the goals. These means of implementation are all based on international cooperation. The agenda actually separates these means of implementation into two separate streams. One stream is captured by SDG 17 and its 19 targets. The second stream flows from the alphabetical targets in the first 16 goals of the 2030 Agenda. These are also referred to as the ABC targets. For instance, in the context of SDG 16 that I've just referred to, after the numerical target 16.1 to 16.10, we have the alphabetical target 16.A, which requires states to strengthen relevant national institutions, including through international cooperation, for building capacity at all levels, in particular in developing countries, to, among other things, combat crime. SDG 17, which is the general means of implementation goal for all the preceding 16 goals, also records the commitment of states to ensure international cooperation in technology and capacity building, which also applies to efforts by states to combat corruption. In sum, sustainable development cannot be realized unless corruption is combated, and that in turn requires international cooperation. Insofar as human rights are concerned, there is ample work done by various human rights mechanisms of the United Nations and in regional organizations to place a spotlight on the adverse impacts of corruption on the realization of human rights. In general terms, realizing human rights requires an enabling environment at both the national and international levels. Corruption erodes this enabling environment. For instance, under the International Covenant on Economic, Social, and Cultural Rights, states are obliged to maximize available resources for the progressive realization of those human rights, including health, education, social security, housing, food, etc. Corruption diverts these vital resources, and the adverse impacts are felt disproportionately by the disadvantaged groups and persons. Similarly, corruption leads to violations of civil and political rights. For instance, it weakens public institutions and the rule of law. Decision makers have monetary gains in mind rather than interests of society. Corruption in judiciary and police puts a deep dent into access to justice and safety and security of the citizens. A culture of impunity is fostered as a result of corruption, which impinges upon the realization of all human rights. In particular, the right to development is directly violated as a result of corruption. In my work as chair of the United Nations Expert Mechanism on the Right to Development, we have found that adopting and operationalizing the normative framework of the human right to development in combating corruption provides perhaps the best pathway to realizing both sustainable development as well as all other human rights. Corruption poses a serious obstacle to the realization of the right to development. And so operationalizing this right means that the fight against corruption is not seen merely as an objective unto itself. It is also seen as a means to an end. In this framework, combating corruption plays a vital instrumental role in realizing the right to development and thus sustainable development and all other human rights. What makes the right to development framework so appropriate in addressing corruption is its insistence on international cooperation as a duty of states and not merely as an option or good practice. States also have extraterritorial obligations under this framework, to adopt national measures that do not violate the right to development of others. So in this sense, the international cooperation provisions in the United Nations Convention Against Corruption are required to be discharged by states not only because the convention requires it, but also because not doing so will violate the right to development and all other human rights of persons in states where the proceeds of corruption originate. Finally, the operationalizing the right to development in combating corruption also means ensuring respect and protection of all other human rights, such as equality before law, right to information, freedom of speech and expression, as essential elements in the fight against corruption. To conclude my intervention with one last observation, while corruption has rightly been acknowledged as resulting in adverse impacts on human rights, it is perhaps time to frame corruption itself as a human rights violation. Thank you very much. I'll stop with my.
Thank you so much, Professor Canary. We truly appreciate that you are joining us from Costa Rica, indeed. We appreciate that because we are aware of the time zone and your insights about development as a cross-cutting issue in the framework of international cooperation for combating corruption is a quite important element. We have been receiving some messages from participants who would like to listen a little bit more about your thoughts in this regard. If you have prepared any paper in this regard, or if you can share later any useful source that you think could be a good complement to your presentation, we would appreciate that. We will come back to you for further questions. I just want to highlight that Dr. Canade currently chairs the UN Expert Mechanism on the Right of Development, on which he was elected as a member in representation of the Asia Pacific region to draft an international legally binding instrument on the right to development. Also, prior to academia, Dr. Canady practiced for several years as a lawyer at the Bombay High Court and at the Supreme Court of India. So his wide and inspiring experience is a great added value without any doubt to this conference. Now, to continue with, I have the pleasure to receiving Ms. Viola Bülscher, Head of Program, Anti-Corruption and Integrity at the German Agency for International Cooperation. She has a wide experience on human rights and mediation, social corporate responsibility, development, and peace building. Madam Bülscher, you have the floor now.
Thank you very much. And first of all, I would like to apologize because I was late in the talk, and I'm happy that at least I could listen to the last part of Mr. Canada's speech, and I found it really interesting and important the connection to human rights and the right to development. Thank you very much for inviting me for this really relevant panel. I am Viola Bülscher. I'm the head of Anti-Corruption and Integrity Advisory Program to BMZ. The BMZ is the German ministry, and we at the GIZ, we do implement projects for the BMZ. I guess on day 2 of this global conference, I might not have to stress the importance of anti-corruption for you, participating expert. Yet one aspect is of particular concern for us in international development cooperation. The fact that more than twice the amount of ODA is leaving the African continent in form of illicit financial flows, including corruption. This undermines all our development efforts and puts the achievements of the SDGs at serious risk. There are real victims behind the numbers, and especially marginalized groups and people living in poverty are most affected by corruption. That's why we at the German Corporation for Development do focus on anti-corruption. Next slide, please. Our sector program, which I'm heading, provides advisory services to the German Ministry for Economic Cooperation and Development. We have different duties. So first of all, what I have just mentioned, we provide advisory services, and then we cooperate with UN agencies, further bilateral donors, civil society, and think tanks. For instance, we work together with Transparency International, the UFO Anti-Corruption Resource Center, UNODC, the Basel Institute, CIFA, Hertie School, etc. Because our project, as a sector project, has, let's say, the responsibility or the duty to try to integrate anti-corruption within the German development work. The German corporation started in 2006 to work on anti-corruption, and the first official and binding strategy on anti-corruption was published in 2012. And right now, recently, this was updated with a new strategy, acknowledging the importance of anti-corruption to achieve the Agenda 2030. So a so-called quality criterion on anti-corruption and integrity has been developed by the ministry. And this means that this quality criterion, anti-corruption and integrity, has to be integrated in every project in every country by all the governmental implementation agencies. The main aim of this quality criterion is to mainstream anti-corruption. So this means that besides financing specific anti-corruption projects, the integration in all sectors will be our main focus during the next years. So what does it mean, or how to mainstream? So one issue is, or one strategic activity is building anti-corruption capacities within the staff of the German Development Corporation, and to focus on anti-corruption capacity within priority sectors, for instance, climate financing, and then to develop sector-specific risk assessments and mitigation measures. Next slide, please. Then we use, or we try to support the ministry in policymaking and to put anti-corruption on the international agenda. So our project is advising the ministry on how to foster anti-corruption in international discussions, agendas, and events. So all of you know the most important international events, and maybe the newest one is the Biden Summit for Democracy, end of the last year. So because we see that at the international level, we have identified that there's maybe a window of opportunity for the work on anti-corruption. So we see that the international agenda pushed the global fight against corruption, and we try to use it for our own work. And then a third strategic approach for us is to try to improve policy coherence between different German ministries, other strategic partners, and the German Development Corporation is imperative. So what we do is to give some examples, for example, to develop and to implement side events during the cost, to put the focus on the gender aspect within anti-corruption activities, or to promote better donor coordination in cases of corruption. For example, make use of international tools such as from the OECD ACT developed rapid reactions to corruption, the coordinating donor response. Next slide, please. So what is our strategy to try to get to mainstream anti-corruption within the German Development Corporation? So first of all, we are developing a knowledge hub. So this means that we tried to identify and to collect experiences of operational GIZ projects in partner countries and of good practices from other important actors such as Transparency International. And then we try to develop and to pilot new tools, including digital tools, for example, against gender-related corruption, and we do understand corruption as human rights violation. So therefore, I was really happy to listen to the last part of Mr. Kanada's speech. For instance, we developed an anti-sextortion app in universities in Nigeria. Or we developed a judicial integrity scan, and we have a tool, the name is AC Works. So since we understand that sextortion is a very specific gender-based part of corruption, we tried to work specifically on gender-related corruption. And therefore, we developed together with the private sector, with the company and with the Nigerian Civil Society Organization and Transparency International chapter in Nigeria, CISLAC, we implemented a project that offers a digital platform for all those who have experienced gender-related corruption in universities in Nigeria. So by using the application, users are free to report cases of gender-related corruption and thereby provide CISLAC with information and evidence, which, if sufficient, will be forwarded to the highest anti-corruption instance in the country, called ICPC, for further prosecution. The application as well as the database are fully compliant to all relevant data security laws. And for instance, the judicial integrity scan, we developed the scan based on the Bangalore principles. And with this scan, we are able to analyze the judicial system in our partner countries before we start to cooperate with the justice system to make sure that, let's say, the problems of corruption and integrity in the justice system will be part of cooperation projects when we do cooperate with justice systems. And then we have developed a tool, the name is AC Works. This is a capacity building tool and the planning tool for all our projects of the GIZ in the different countries to try to make sure that anti-corruption and integrity will be a mainstream issue of all sector-specific projects in all our countries, partner countries. Thank you very much.
Thank you, Madame Bolcher, for your important comments. Thanks for highlighting the importance of partnerships between private and the public sector. This is quite important, and this is in line with the SDGs 16 and 17, which are related to, respectively, to peace and, of course, to the combat against corruption, and the importance of joining efforts among different stakeholders. Now, to continue with, let me welcome Madame Gladys Pickering, who is Company Secretary at the Namibia National Reinsurance Corporation. Previously, she served at the Ministry of Justice in Namibia for several years. Among other responsibilities, she was the Executive Director, Deputy Chief, Legal Services and International Cooperation, as well as lower courts and Master of the High Court. She was also legal attaché for human rights issues at the Permanent Mission of Namibia to the United Nations in Geneva, and manager on trust and estates at the PricewaterhouseCoopers. Mr. Pickering, now you have the floor.
Thank you very much, Thank you, Ana Lucia. And a word of thanks to UNITAR and ROLAC for the invitation to speak as a panelist on this very important topic, which is something that is very topical in Namibia currently, and which Namibia spends a lot of time and resources on, and that is the combating of corruption. Namibia, as a member state of the United Nations Convention Against Corruption, but also as an African state, being a member to the African Instruments on Combating of Corruption, has been at the receiving end of very high-profile corrupt cases. And I will talk about that later on without mentioning any institutions or any countries in that regard. What I would like to start off with is to indicate or give a brief history on the background of Namibia and how we have since 2003, how we have enabled ourselves to be able to cooperate with other states on the combating of corruption. Now, Namibia had a domestic law on combating of corruption prior to Namibia having become a state party to the UN Convention on Corruption. So we already had domestic legislation even before the UNCAC came into operation, before we became a member state there too. It is important for us to note this, as we have made several changes to our domestic framework to enable us to have better cooperation with states in combating of corruption. It is also important to note this, as our domestic legislation is the primary enabler for us to focus on preventative measures, and also to have our assets, return of assets. We also have, in an effort to enhance our domestic framework, we have enacted the Prevention of Organized Crime Act. This legislation was very instrumental over the past 10 years at least in returning of assets to Namibia, and also in seizing assets and or attaching assets under preservation. We've had very, very successful cooperation with states in the past as a result of Namibia being a state party to the conventions, but also because we have put in place domestic measures that have enabled us to do so. In this regard, I would like to also indicate that we have spoken, and the panelists yesterday have spoken extensively on the AU instruments and other instruments that can be used and how those instruments can be invoked in the fight against corruption. I will also not go into the details on how corruption impacts the enjoyment of human rights, but I want to say here that as a result of high-profile corruption cases, Namibia was unable to provide adequate health services, facilities, and amenities to the population during the COVID-19 pandemic. And that is exactly what was highlighted by the UN Secretary General when he highlighted the 5 alarms that we see emerging and impacting on the whole issue of building capacity to face global emergencies. So when we look at those 5 alarms, which were sounded by the UN Secretary General, we will see that these economic inefficiencies and inadequate resources is a direct result of the impact of corruption. And this brings me to the case which I would like to highlight. In recent years, Namibia had a very high-profile corruption case that involved cabinet ministers and high-profile politically exposed persons. Our law enforcement agencies have acted very swiftly in the investigation of that matter, and as a result of those investigations, those high-profile persons were arrested, and they are currently still incarcerated awaiting trial. The case was of such a magnitude, and I can speak of this case because it is widely known, and I have also been at the time the responsible functionary as the central authority within the Ministry of Justice, working with other countries to finalize this investigation. Because of the magnitude of the case, which involved more than 12 countries with which Namibia had to cooperate in bringing the evidence to Namibia and in ensuring that we finalize this investigation within the shortest time possible in order to secure evidence, to secure the integrity of the evidence, and also to ensure that the rights of the accused persons are not violated in the process. This has put an enormous burden on the very limited resources and expertise that we have in the country. In that regard, the UNODC and many states across the world have enabled and assisted Namibia greatly in building bridges for us to connect with other states, putting us in contact with expertise in other states and organizations outside of the UN framework or outside of the governmental frameworks, which has greatly enabled us to finalize the investigations in this grand corruption case within a record time. Of course, now we are at the point where the trial for this matter is soon to start and where the evidence will be tested in the court. We do have a very strong judiciary, impartial and very competent. However, when we talk about corruption and international cooperation, it is very important to note that states, to this day, we use our domestic laws as an excuse not to cooperate with other states when they need that cooperation most. Therefore, as the United Nations Convention Against Corruption and other regional instruments, including the African Instrument on Combating of Corruption, as those instruments enable us to cooperate with each other in the widest measure possible. And it provides us with so many enabling provisions on extradition under Chapter 4, as well as mutual legal assistance under the same chapter to cooperate with each other. It should be highlighted that where states like Namibia are unable to call upon another state to cooperate with it because of the domestic legislation of that state, it is rather unfortunate. As we should, as a collective and as the world, as a global community, we should enable ourselves to cooperate with others when they need us to in the widest measure possible. So in that regard, Namibia was able to cooperate with most of the states under our own domestic framework, but also under the domestic framework of those states and in terms of the international instruments. Of course, when we look at, there is a report which is available online on the UNODC website. It is a report that emanates from the international governmental expert. It is an intergovernmental expert meeting that is held every year under the auspices of the UNODC to enhance international cooperation. They have released a report on statistical information on the use of the UNCAC as a legal basis for extradition, mutual legal assistance, and law enforcement cooperation. In terms of that report, the statistics shows that at least 50 states parties to the convention are able to use the convention as a legal basis for extradition, and at least 22 cannot use the convention as legal basis. What is more interesting is that states parties that can use the Convention Against Corruption as a legal basis for extradition by regional group indicates that the African group represents the most states that can use the Convention Against Corruption, the UN Convention, as a legal basis for extradition. And it signifies at least approximately 25 states within Africa that can do so. What is more important is that on mutual legal assistance in terms of the UN Convention, it is again the African group that shows the most states that can use the Convention Against Corruption as a basis for mutual legal assistance. This is very significant for many reasons, because some of our previous panelists, or our current panelists, the previous speakers, Mr. Kanade and Ms. Bulsher, has indicated the amount of funds or money flows, illicit flow of funds out of Africa. So it is almost expected that African states would position themselves to be able to cooperate with other states when it comes to combating of corruption, to the extent that we are able to curb the illicit flow of illicit funds out of Africa. But when it comes to big transnational corporations and bribery and corruption committed within certain sectors in developing countries especially, and here I refer specifically to Namibia and to the corruption case that I referred to earlier, which involves a corruption scandal within our fishing industry. Our fishing industry is one of the biggest contributors to our GDP, and it provides work for many, many Namibians. Now, in that fishery corruption scandal, approximately 600 Namibians' jobs were at risk, which means that their livelihoods and those who depend on them are also at risk. Many have lost their jobs. They were dumped into poverty as a result of that. And for Namibia, as a country where unemployment and poverty levels are very high, it is necessary for us to guard against incidences like these. So on the issue of human rights, the impact of corruption, and coupled with that, the impunity with which transnational corporations commit corrupt acts in developing countries, it is a recipe for disaster, which we can curb or we can combat through proper cooperation, using the instruments that we have at hand, and also positioning ourselves as states to be able to cooperate with each other. Now, I would just like to, I think I have almost reached my 7 minutes. And I also forgot to say at the beginning that today is Africa Day. So happy Africa Day to all Africans and to the world. Because there is no Africa without the world, and there is no world without Africa. So happy International Africa Day. So what I would like to say in conclusion is that if we want to reach our sustainable development goals as a global community, if we want to combat corruption, if we want to see that countries like Namibia and other developing countries in the world do not fall victim to impunity of transnational corporations that act as sovereigns in their own operations with great impunity, and if we do not want to see levels of unemployment and poverty rising in developing countries, we need to pay particular attention as to how we can enhance international cooperation, how we can use our resources and our expertise around the globe to partner with each other to make sure that when cooperation is needed, it is granted, and that we do not find excuses not to be able to cooperate with each other. And on that, I would just like to share 2 images. I think it was Mr. Kanade who referred to the Transparency International Global Index on Corruption. What is very interesting is that the Transparency International also shared with us a financial secrecy index. Now, I will first put the Global Corruption Perception Index on the screen. I hope I can manage to put it on.
Okay, you're about to share a screen, right?
Yes, I'm about to share a screen. And I do not want to waste time if I cannot find it. So I will just try and see if I can find it quickly, because this screen or this slide that this image that I want to share with you, I can't, I'm not able to upload it. Be that as it may, I will open it quickly on my site and you can look for this online. It is the Corruption Perception Index for 2021, showing what was referred to earlier, the rank, the country, the score, the change compared to 2020 and from 2012 to 2020. So there we see in the top 10 rankings, Denmark, New Zealand, Finland, Singapore, Sweden, Norway, Switzerland, the Netherlands, Luxembourg, Germany, etc. What is very interesting is that Transparency International also released a financial secrecy index in 2022. Now, in the image that you will find online, you will see on the right-hand side, on the left-hand side, you will have the financial secrecy index, and on the right-hand side, the corruption perceptions index. Interesting, the countries that are ranking top 10 in the corruption perception index are also some of them, at least 1, 2, 3, 4. At least 4 of those countries are also the top 10 amongst the top 10 ranks for financial secrecy index in 2022. Why am I highlighting this? Because the reality is that whilst those countries are doing very well in their own territories to combat corruption, it is also true that the corruption conducted or committed in other countries and in other regions in the world, they are the ones that suffer the consequence, whilst these countries that are ranked top 10 are not, the financial secrecy aspect curbs or it hampers the combating of corruption in the countries that are on the top, the lower ranks of the corruption perception index. So whilst some countries are at the lowest levels on the corruption index, the countries that are at the highest level, they are the ones that have the financial secrecy aspect, which is a challenge, and it poses a challenge to those who are fighting corruption and are ranking lowest in the indexes. So unless we get that equation correct, and unless we make sure that international cooperation is not stifled because of domestic laws and other things like financial secrecy, we will not win the fight against corruption. So I think I've reached now really the end of my time. Thank you very much for this opportunity.
Thank you so much, dear Gladys, and happy Africa Day, of course. That's the first thing. And to all the participants who are joining us, of course, we extend our congratulations. And thanks also for highlighting, among many relevant facts that you have shared today, you highlighted one core aspect related to the combat, related to combating corruption, which is the independence of judiciary and separation of powers. And thanks also for sharing the African experience. Now to continue with, we will be having Dr. Ehab El-Sombati. He's partner in New York, Middle East, Qatar at DLA Piper. Dr. Ehab focused his practice in the area of corporate law, focusing on the Middle East, Gulf countries, and Qatar. He was former head of governance and governmental affairs at the Qatar Investment Authority. He has wide experience in strategic, corporate, and special projects and transactions valued $1 billion, as well as management and investment, including the Crisis Management Committee. Dr. Ehab, the floor is yours.
Thank you. Thank you very much for the introduction, and thank you very much for the opportunity to be with you in this important event. I will not, of course, be speaking about the fundamental principles of anti-corruption and its important relationship with human rights, but I will go through a few experiences, practical experiences that I have gone through in my current job and my previous job in relation to the anti-corruption activities and compliance with the international and local standards. First, I will start with where I am now in DLA Piper. As some of you know, DLA Piper is one of the largest law firms in the world, and we are the largest law firm in Africa with 20 offices. Celebrating with my rest of the African colleagues the Africa Day as well, and we are proud of this, and we are interested in expanding our African practice for sure. DLA Piper, as many of the other international law firms, has zero tolerance for the anti-corruption matters and so on. And therefore, we have very strict policies and regulations that is implemented throughout the world. It is very important for any file to be opened to identify all the beneficial owners, to scan and do a background check on every counterparty and on every client. And for sure, as you can imagine, we use all the systems and softwares and databases that are around, like there is no limit for that. And if there is any red flag that arises, I haven't seen in my experience any suggestion even that we would take over any case that would have been identified as red flagged from any of the systems that are related to this anti-corruption or any of the other international crimes or actions that are prevented by the international standards or local laws. And during the process of the case, this kind of scrutiny and checkup is always being conducted in all the files and affairs and so on. And we have a very qualified team in the general office team. So for your information, in such organizations, everyone is a lawyer, of course, in the firm, but there is a general counsel office in the firm that is the lawyer of the lawyers. And this general counsel office is responsible of monitoring our conduct as lawyers in the firm and the associates and the admin departments and so on, to make sure that we are in complete compliance with the international standards and the anti-corruption regulations and so on. So it is not only a process that we have to check and oversee at the beginning of the process. It is a continuous education and follow-up and very clear scrutiny that there is no tolerance for. And as you can imagine, a very large part, and myself, I am a US person, and my firm is, of course, a US entity, and the standards of the anti-corruption in the US law is higher than many other jurisdictions, and therefore we have to comply with the higher standards, not only in the US side of the firm, but also for the international side of the firm and the African and the Middle Eastern and the Far Eastern side of the firm. We raise the bar to the highest standard possible to show that we are adhering to these high standards and we are implementing this culture throughout the organization. So that is my intervention in relation to my own personal experience for these matters. And I tell you, it gives us a lot of difficulties when we start opening the files, because our teams in the General Counsel Office will be very clear to identify every single document and to do the scrutiny on every potential client in every matter. But I think it is a very good protection for the firm, and it shows a complete compliance with international standards and laws. When I was in-house in Qatar Investment Authority, it is the 7th largest sovereign wealth fund in the world, and it has investments everywhere in the globe. We adopted again the same zero tolerance for any anti-corruption matters. And as the Sovereign Wealth Fund is a very big organization, we have adopted at that time, and I contributed to the drafting of these policies. Again, it is not a US person, but out of complete compliance with the highest standards, QIA selected to abide by the higher standards, being the US or the UK or the international standards, and of course the Qatari standards, and we included them in all our regulations and policies. The second implementing measures that we have adopted in QIA has been always to make sure that the very strong policies and regulations that we have adopted by the board of QIA and the subsidiaries is reflected in the implementing procedures and process. So we were very careful to include the related KYC and scrutiny and screening activities in all our processes, being the procurement processes or the investment processes. And as you can imagine, for an investing entity, the investment process is the bread and butter of the activities of the organization. So has been always a significant milestone for engaging with any counterparty or related party to make sure that we scrutiny and screen every one in all the systems, and to make sure that there is no relevance to any of them, to any of the listed entities or persons. And in the same time, there were a very clear and transparent process in selecting the counterparties and the related parties and the investment targets in a manner that makes sure that we adopt the transparency principles and are giving equal opportunity to the counterparties without any personal discretion or preferences that may suggest that any non-anti-corruption activities are followed. And we have implemented the same thing in the processes that we were following in the procurement. And procurement processes for such a large entity and its subsidiaries is a very significant financial size. And therefore, we implemented the Qatari law standards of procurement to achieve transparency and equal access and opportunity to the bidders to the system. And in addition to that, we were implementing a very robust compliance program for all the officers of the organization, to the extent that we made it compulsory for the employees to pass certain compliance program for anti-corruption, for compliance, and similar important policies in the organization. We made it a condition to be able to receive the annual bonus in the organization with a certain level of success. At some point, it has been always 80% of success results to be allowed to receive the annual bonus. To this extent, the organization has been always very strict in implementing the anti-corruption and adhering to the anti-corruption policies and procedures. And again, as I explained the system and the Piper, it is a continuing scrutiny process. It doesn't stop at the level of the beginning of the investment of the procurement. It is a continuous process. There is a training for all members of the staff, and there is a robust monitoring from from the compliance department at that time to make sure that these rules and the bars that QIA has selected to adhere to is respected throughout the process. And lastly, I was also a part of, and with a cooperation with Qatari Public Prosecution Office. We were very keen not to leave any person or rumors or entity that is alleging any connection with the organization be there or alive without tracing and chasing them with all the possible legal instruments, being the Interpol or the other law enforcement agencies in Qatar and outside Qatar around the world. And I was personally involved in many cases where people were going to some public officials or government entities claiming that they represent my employer. And we were very, very strict and very sharp in taking all the legal procedures to make sure that we show the regulatory authorities and the market and the public that we are not related to these activities, and we were prosecuting to the maximum extent any person or entities that were trying to create the image of a relationship with the organization to this kind of suspicious activities. By this, I would conclude my remarks on the practical experiences that we have had in these two organizations. Of course, in previous lives, as a previous prosecutor and a previous judge in my home country in Egypt, we were involved in many of related activities. But I think sharing with you and with the audience these kind of experiences were recent experiences for global organizations who are committed to contribute to all the international efforts to combat corruption. And I'll be very happy if you have any questions or you would like to shoot me an email later on with any follow-up inquiries. Thank you very much again for the organizers and for the distinguished panel and for the all audiences for your time. And I was honored to be with you today.
Thank you very much, Mr. El-Sombati, for sharing some concrete examples from your experience in the public and private sector. You have enlightened us with some good references related to corporate social responsibility. We will come back to you with questions. Now, I have the pleasure to give the floor to Dr. Yasser Rufai, who is the director of ROLAC.
Thank you very much, Ana Lucia, for the introduction. And I wanted to speak at the end, after all the distinguished speakers finish. Also, I wanted to hear the answers for some questions that very nice questions that I see. And so, on behalf of His Excellency, the Chairman of the Board of Trustees of ROLAC, Rule of Law and Anti-Corruption Center in Doha, I would like to thank everyone who participated in this conference, especially the group of distinguished experts who provided very valuable information in the field of anti-corruption. In fact, the exchange of information, visions, and ideas is very important for fighting corruption. I extend my deep thanks to our important and excellent partner who has led the training process with great success, the United Nations Institute for Training and Research, and I appreciate the great role it plays in all fields. We must come out of this conference with a very important understanding, which is that the war against corruption has not stopped. Corruption does not leave any branch of public work untouched. Economic, political, organizational, environmental, social, and every other type of work conducted by governments is vulnerable. So we had a plan with UNITAR to offer many courses, and we are offering, maybe at the end of this course, we will be offering 3 new courses. So to develop the skills necessary to fight corruption in all areas of public work, ROLAC is proud to have partnered with UNITAR to create a series of e-learning courses on anti-corruption issues. Also, I wanted to mention a very important thing that in our work. So if I can just add one message that is very important to ROLAC, I would like to take the opportunity to inform the esteemed panel of experts and attendees that nomination for this year International Anti-Corruption Excellence Award are now open. We are offering an award, the Sheikh Tamim bin Hamad Al Thani International Anti-Corruption Excellence Award, and to encourage you to submit nominations for anti-corruption fighters in your region. ROLAC, we are the secretary of this award, which celebrates the work of those seeking to combat corruption in their communities and offer a financial prize also to winners to assist with expanding their anti-corruption efforts. Nomination can be for individuals or organizations and can be submitted into any of these categories: innovation, investigative journalism, academic research and education, youth creativity and engagement, lifetime or outstanding achievement. And we are proud also to introduce a new category this year for a new category in the award is safeguarding sports from corruption. ROLAC is, of course, available to assist any of you who wish to submit a nomination. Also, you can visit aceaward.com. Thank you very much, and thank you, Ana Lucia, for giving me the floor. Thank you.
Thank you very much, Dr. Yasser. As expressed yesterday by our director, we truly appreciate our partnership. Now we will continue with some questions from the audience. The first question is for Dr. Kanade. In the framework of the ongoing discussions of the UN Convention on the Right to Development, have you already envisioned elements or components related to combating corruption? That's the first question. We will come back to you in the second round with another question. You have the floor now, please.
I'm sorry, could you repeat the question in the context of which negotiations?
The Convention on the Right to Development.
Oh, yeah. Yes, absolutely. The discussions on corruption have been quite at the center on, in the discussions or negotiations on the upcoming potential convention on the right to development. And very interestingly, these have been brought forth by the developing countries, not the developed countries. And I'll combine this with one of the questions that I see in the Q&A, which is from Mr. Uribe as well, about how international human rights frameworks could be used as a tool against corruption, because these are very related concepts. A dominant narrative that comes up often in literature is the importance of adopting a human rights-based approach to addressing corruption. However, in my experience as chairing the negotiations also on the Right to Development Convention, I've noted that there is a tremendous amount of resentment and opposition from developing countries against the deployment of the term or the framework of human rights-based approach to development. And this is not without reason. This is linked also to a point that Ms. Pickering made, and I'll expand on that. Human rights-based approach to development, including in anti-corruption measures, in the manner in which it is deployed by development cooperation agencies or developed countries, focuses predominantly on the obligations of the recipient countries, recipients of development cooperation, on how they implement their human rights obligations while implementing development projects. However, the obligations of the development cooperation providers in respecting the human rights of the recipients is not necessarily taken into account. And that's the reason why most developing countries are promoting what is called the right to development approach rather than human rights-based approach to development, which makes development itself a human right. It doesn't treat human rights and development as two separate things like human rights-based approach to development does. It looks at development itself as a human right. Why is this important? Because in the right to development normative framework, we are looking at not just the obligations of states internally to respect human rights, but we're also looking at the extraterritorial obligations of states when they adopt national measures and how their national measures are impacting human rights of others. We're also looking at the obligations of states collectively in global and regional partnerships to realize human rights, particularly the right to development. What happens, I'll give you the example of development cooperation. Ms. Pickering pointed out, for instance, that we have the index on corruption, and she pointed out the top 10 countries. And she also noted that we have the global financial secrecy index, which runs parallel to it. She did not read the list of countries, but I'll take the opportunity to do so. And these are the list of the 10 most secret financially countries: United States, Switzerland, Singapore, Hong Kong, Luxembourg, Japan, Germany, UAE, British Virgin Islands, and Guernsey. Now, why is this very important? Because in the context, let's say, of development cooperation, including the OECD reports, it's very clear that when development cooperation is given, let's say by a European Union country or some others to a country in Uganda, the choice of sectors to which that development aid would be given is decided by the developed country, by the donor country. Recipients hardly ever have a say in that. And the evidence demonstrates, and my own research demonstrates, that the sector that is chosen typically for development aid, including aid for trade by developed countries, is roads. Roads are basically sold on the idea that, look, your products from the interiors will now get access to the exteriors so that you can export products to rich countries. But this also means that now Coca-Cola and other transnational corporations from the rich countries have an easy access to the interiors of the developing country. Evidence demonstrates that the exports from developed countries far surpass, they grow a lot more than the exports from the recipient countries to the donor countries as a result of this development cooperation. But what's worse is this, and this is linked to the point I'm making about corruption and financial secrecy that Ms. Pickering made. Most OECD contracts by developed countries that are linked to development aid, and development agencies are all part of this, unfortunately, insist on in-donor contracts, which means that if a European Union country is going to give a contract for construction of road to Namibia, the condition of that aid is that the construction of the road would be done by a European company. Now, if you do the mathematics, what does this mean? This means that let's say it's, a particular European country, the money that is given to Namibia is that particular country's taxpayers' money. That taxpayers' money is going through a long circuitous mechanism of development aid and actually filling up the pockets of the European company. Now, there is definitely an element of corruption in this. Ms. Pickering pointed out the corruption by transnational corporations, but development aid also fosters this corruption. But if you do the mathematics in total, this means that Namibia has to repay the development aid it is receiving with interest anyway. But on top of that, the initial amount that has gone to Namibia is also coming and filling the pockets of the European company that's constructing the road. And this is the reason why in the discussions on the right to development, and when we talk about a human rights framework, it is very important that we do not stop at what typically is called the human rights-based approach to development, which looks at only what Namibia is doing to its own people. It is also important that we adopt a right to development normative framework, because development agencies and donor countries also have an obligation to respect the human rights and right to development of the recipients. Thank you.
Thank you so much. Really good answer. Now to continue with Dr. Bulcher, could you please let us know your thoughts on the role of international cooperation for resilience and recovery? This is in the framework of COVID. What are the changes that you have experienced in terms of priorities that you had settled before COVID, and now with all the situation that we are still in that situation? How do you think that we can overcome this to have more resilience and recovery?
Yeah, thank you very much for this question. I'm still thinking about all the things Mr. Kanade has just mentioned related to the development agencies. Just to make it clear, so I share a lot of your thoughts, Mr. Kanade, and we as the Anti-Corruption and Integrity Project within the GIZ, let's say, we understand ourselves as the Anti-Corruption and Integrity NGO within the development agency, at least to make sure if we do all the things like building roads, etc., that at least there is anti-corruption, that anti-corruption has been mainstreamed in all this project. Coming back to your important question, Mr. Krum. This is really interesting because right before COVID has started, the German Development Cooperation Ministry, they decided to not to stop working on the health sector, but to put it off the priorities of the sector-specific cooperation projects. And right now this has been changed again. So to work on health and to have a One Health approach. So this includes health, human rights, environmental issues, etc. So to have a more integrated approach to all this sector. And then, sorry, but I have to use the term human rights-based approach. The German ministry, I mean, this is the second quality criterion, the human rights-based approach. So because it's always the same, if you get a lot of money to respond to a really important situation as the fight against the pandemic, you get a lot of money and it's important to spend it right now. So you have always the higher risk for corruption, for not complying with the gender mainstream, with the human rights-based approach, etc. So this was the second very important strategy for the ministry to make sure that even in this process, which had to be very fast to implement projects against COVID, let's say, that it was guaranteed that the human rights-based approach was implemented, and to integrate all the anti-corruption and integrity measures. And right now, since I mentioned before that our main duty right now is to mainstream anti-corruption, and this is quite new for the German cooperation, for example, is to focus, for example, on climate financing, on the climate financing issue and on the health sector, and because there is a lot of money in, and these are always the most sectors at risk for anti-corruption. So our strategy is to develop sector-specific corruption risk assessment, to understand better, so where are the risks, or what are the risks, and then to understand, so how could we respond to the risks. So we have just met with a person from the World Bank, and they explained that it's always really complicated to use a legal approach, because normally it's really difficult to have enough evidence to show that there has been corruption in any project, so that they try to implement more mediation, negotiation, and other negotiation tools for fight the corruption within the sector. And I think so we have to do some more research on this issue to improve our own strategies and tools to fight corruption when we spend a lot of money. Thank you.
Thank you very much, Dr. Belcher. Now, Madame Pickering, considering that corruption represents a two-way street, what tools could be utilized for preventing corruption from the standpoint of view of the private sector? Would due diligence requirements for business corporations be enough, or increased principles of transparency and reporting would be necessary? The floor is yours.
Thank you, Anna. Definitely, as we have seen in the past, and I have been from the national perspective involved in various working group sessions at the Human Rights Council, at the UNODC, and these working groups, and I will refer specifically to the working group on business and human rights, and also the open-ended intergovernmental working group on human rights and transnational corporations and other businesses, and also the implementation review group sessions under the auspices of the UNODC. Now, in this regard, we know that various tools or guidelines are available for private sector to adhere to good governance strategies, to ensure that they conduct due diligence, and to ensure that their businesses do not impact adversely on the enjoyment of human rights. However, if I can only refer to the UN guiding principles on business and human rights, we have seen that private companies, especially transnational corporations, have, with continued impunity and complete and flagrant disregard for the rights of the people, continue to conduct their affairs in such a manner that it is unacceptable. It is unacceptable in the first place. It is against the international human rights standards and laws. And in addition to that, there's very, very little that affected communities, affected individuals, and affected states can do to claim damages, to claim reparation, and also to hold those entities accountable. So if we are talking about tools that can be used by private sector, those tools are already there, but those tools are not strong enough, it is not compelling enough, and therefore the entities, the companies, they just have this attitude of impunity, because very often you will see, and I come back to the fisheries corruption scandal in Namibia, where transnational corporation was seen to almost be stronger and more influential or more powerful than the state itself. And that is quite significant to note, because if we say that we want corporations to be accountable and to be held to certain standards, and yet those tools and standards that are in place, which they can use, they are not using. And it doesn't matter whether we have national human rights action plans or we have implementation plans for the UN guiding principles or whatever, and you have no recourse against the perpetrator. It does not mean anything at all in the end. So what would be good is if we could have more stringent instruments, if we could have more stringent tools that should be compelling for corporations to adhere to. And that must not only be applicable to certain parts of the world, it must be applicable to the entire world. It must be applicable to all corporations, all states where these corporations conduct their business. And there must be cooperation. Again, the issue of cooperation among states. Why should it be necessary for people in Namibia who already do not have the means to conduct very expensive and time-consuming litigation to go to a court in the UK to be able to claim some reparation for conduct that occurred through the transnational corporation through its subsidiary in Namibia. There should be more available avenues for recourse, and there should also be more compelling and stringent tools and measures applicable to private sector businesses as there is to states. Of course, we all know that states are sovereign. No state can be forced or compelled to become a member to any instrument. It is the prerogative of that state. But as a collective, we should be able to, as we were able to do under the UNCAC, we were able to do that under the UN Convention Against Corruption. We should be able to do that also on the right to development and also on transnational corporations and other businesses to hold them accountable in a more compelling manner. Thank you.
Thank you very much, Madam Pickering. Now, please, Mr. Elson Bati, what do you think about the next question? How do we deal with corruption in systems where there is little or no laws regulating the operations of the private sector? The floor is yours.
I think this is a very wide question, and we really need to illustrate the concept. So we are speaking about a legal system that doesn't consider corruption activities for private sectors. If this is the question, I wouldn't think that any jurisdiction that I'm aware of in the world doesn't have anti-corruption laws or regulations or policies, even for private sector. So we have to differentiate between two things. The first one is in a specific jurisdiction, let's say country A. Maybe the question is suggesting that the laws that is combating anti-corruption in a specific jurisdiction is not focusing or detailed enough to combat anti-corruption in private sector. In this case, as you can imagine, it is up to the legislative authorities being pushed by the NGOs or the other institutions in the civil society to strengthen and empower the legislative framework for anti-corruption activities even in the private sector. And moving forward from that, if the question suggested that the system, meaning the implementation system, the law enforcement, the public prosecution, or the responsible department in the police is not taking the private sector corruption as seriously as the public sector, I think it is again a matter of education, lobbying, influencing these departments to put more attention to the anti-corruption activities for the private sector. And it really depends on how big is the private sector in a specific jurisdiction, thinking about it. Because if you think now, in many of our countries, many of the economic activities is still connected to the public sector. So if we are talking about a case where a private sector is involved in an anti-corruption or a corrupted case with a public sector entity or a public sector fund or a public sector procurement, this will be covered by the public sector anti-corruption laws and regulations, because as you know, in most of the jurisdictions in the world, whenever the public fund or the public money is involved, it is considered a public sector anti-corruption case, and the highest penalties in the criminal code will be implemented. But if it is private sector to private sector corruption, I think it will all depend on the size of these deals and the transactions in the private sector. And in a pure capitalistic system like the US or maybe UK, of course, this may happen, and therefore the anti-corruption scrutiny and legal framework is as strong on the private sector as it is on the public sector. If it is in a more socialist regime where the private sector roles is less and the size of transactions between private sectors entities is less, it will not be as important, but it is always the roles of the organizations like the organizers now to educate, to spread the awareness, and to influence the responsible entities to empower or extend or expand the legal and the implementation measures to combat the corrupted activities, even if it is related to the private sector. I tried to answer it from a holistic point of view, but of course, if the attendees has further clarification or maybe a specific angle we would like to cover, I'm very happy to elaborate further.
Thank you very much for your comments. Now, I would like to go back to Dr. Kanade. What do you think about the next question? What are the strengths and challenges of developing countries in the framework of international cooperation for combating corruption? The floor is yours.
That's very broad question, and that could be answered in many ways, but I think the internal obligations of states to combat corruption is a given. That's an obligation that already exists, both under domestic law, constitutional law of countries, and also international law flowing from the Convention Against Corruption. The main job of governments is to govern, and govern in the interest of the people. So good governance is both a constitutional duty of most countries and also flows from international obligations. The point about addressing or combating corruption is that it requires an enabling environment, and the enabling environment both at the national level and at the international level. There is definitely a huge problem in many developing countries, but also developed countries with relation to addressing corruption at the domestic level. And one must never lose sight of the fact that corruption is prevalent in both developed and developing countries. In fact, some of the largest corruption cases that we know of have emerged in developed countries or in recent memory. The problem with combating corruption is, number one, lack of political will, lack of adequate measures, adequate systems in place at the domestic level. But at the same time, as we've been pointing out, corruption doesn't get fostered in a vacuum. There is an enabling environment that's required to be created for corruption to take place. And both the receiver of corruption and the provider of corruption are important stakeholders in this discussion. When I talk about international environment, there are many different ways in which this can be looked at. One obviously are the international actors, whether transnational corporations or others, who provide the resources for corruption at the developing countries level. There are obligations that need to be looked at there also. And I think we've had discussions on transnational corporations. A lot of corruption takes place, at the behest of transnational corporations. The latest statistics demonstrate that 73 of the top 100 economies in the world are corporations and not nations. And so it's important to stress again that the size of corporations and the ability to have adverse human rights impacts or adverse impacts on sustainable development far surpass the ability of many of the host states to deal with those adverse impacts. This is what John Ruggie in his guiding principles called as the governance gaps. These are governance gaps that exist. Of course, the problem with the UN guiding principles were that they, number one, did not accept that home states of corporations have obligations to regulate their own companies' activities elsewhere. And the second problem with the guiding principles was that they did not accept that business corporations have human rights obligations directly under international law. And both these things are sought to be regulated and rectified rather in the Treaty on Transnational Corporations that's being negotiated, but also in the Right to Development Convention. Both transnational corporations as well as states also have extraterritorial obligations to ensure that they do not violate human rights of people elsewhere. So the point that I'm trying to make is that dealing with corruption has to be holistic, has to be looked at as a comprehensive issue. There is definitely a huge case to make that corruption originates, corruption thrives in a domestic environment, and that definitely needs to be addressed. However, it would be a huge fallacy to assume that corruption thrives only in a domestic environment, because the enabling circumstances for that to thrive also many times are compounded or actually facilitated by an enabling international environment, which comes from other countries, which comes also from transnational corporations. So we cannot be selective in how we address corruption, how we combat corruption. A holistic solution to addressing corruption must focus on all sides of the equation, and this necessarily entails international cooperation. And the reason I pointed out the right to development as an appropriate framework to look at this was that under this framework, international cooperation is not just an option. It is not charity. Cooperation is not charity, it's not generosity. Right to development makes development itself a human right, but also guarantees that international cooperation is seen as a duty of all states. It's an obligation of all states, not just a moral choice. And this is where I think a lot of attention needs to be paid in combating corruption in a holistic manner. Thank you.
Thank you so much, Dr. Kanade, for your holistic approach. Now, the following question, I would like to invite Madame Belcher and also Madame Pickering to reply this. Most countries have anti-corruption legislations in place within their legal frameworks. However, political goodwill lacks, same as Mr. Kanade highlighted before. This could be in various forms: inadequate resource allocation to anti-corruption agencies, political pronouncements unfavorable to anti-corruption fight, threats to change anti-corruption laws, etc. What is your strategy to assist countries dealing with this? Madame Belcher, you have the floor now.
Thank you very much. Yeah, this is always a real big problem, and I think that in many countries you can find very good constitutions, very good human rights laws, good institutions, and in many countries really good developed anti-corruption laws. So for us as the development cooperation agencies, it's absolutely complicated to cooperate with countries who have good tools in place, but maybe when they are not politically willing to use them. So we have no, let's say, we have no tools or no options to force them. For us, it's always easier to support countries when they say, okay, we are interested in to improve our anti-corruption system, but we need technical support for this. So then it's absolutely easy for us to give them this kind of support. But we can't push them to make use of their instruments and their tools as a technical cooperation agency. So there, I think it's absolutely important. It's very important to have the internal political coherence, that it's important to have a dialogue more on a political level, and maybe to try to make use of other regional or international, let's say, conferences, institutions, or whatever, to push them, but more on a political level. And this can't be our our business as a corporation agency.
Thank you very much, Madame Bircher, for your insights. Now, please, Madame Pickering.
Thank you, Ana Lucia. Of course, as I've also typed in the Q&A section, in democracies where voters have the right to demand certain action, and they would like to see, and not just have a promise of an action to be taken, they would like to see that promise culminating in real substantive actions on the ground. It is important that the people know their rights, that the people know what they can demand, that they can demand the political backing and political will to combat corruption. And of course, politicians should be held accountable and be forced to address the issues and to put their weight behind anti-corruption initiatives. But what is more important here, and that was part of the discussion yesterday, some of the panelists yesterday alluded to the importance of the freedom of the press and the value of investigative journalism. In Namibia, that has served us very well. The value of investigative journalism and the freedom that the press enjoys in Namibia has served the Namibian people very well in bringing the information to them so that they are able to make the demands that would culminate in anti-corruption actions that will have a significant impact on the matters. And it is because of the people using their power and their rights that certain things were able to happen. But if that is lacking, and especially in societies where those rights are not very well protected, where people are not able to enjoy those rights and to demand the fulfillment of those rights, and where information is withheld, it can become an even bigger problem because their political will can be even further stifled. So I think that is definitely what can be done in order to force political will and political backup. Thank you.
Thank you very much, Madame Pickering, for your comments. Now, let me give the floor to Dr. Ehab. Can you please let us know what are the most common features in a system that could be appealing for investors regarding policies for combating corruption? Dr. Ehab? Is Dr. Ehab with us?
I don't see him in the room. Sorry.
I guess he is disconnected now.
He's connected now? Ah, okay. Dr. Ehab?
Yeah, he's not with us now.
Oh, he's not with us. Okay. Okay. Okay, now, please, dear speakers, could you please share your final thoughts before we close this third panel and we proceed with the launch of the e-learning courses? Please, Dr. Kanade, you have 2 minutes for your final insights.
Thank you very much. I think I'll just reiterate the key points, the key messages that I've highlighted here. The corruption is a serious obstacle to the realization of human rights, and particularly the right to development. What makes the right to development framework so attractive is that it brings together sustainable development as well as human rights as the end towards which anti-corruption measures serve as a means. So when we look at the Convention Against Corruption, and all the international cooperation procedures and mechanisms that are suggested in the convention. Those measures would be served better if they are not looked at as an end in itself, but as a means to an end, and those ends being realization of sustainable development and human rights. However, corruption thrives in both a national and an international environment. Good governance is not the domain only of states internally. Good governance also needs to happen at the international level and also at the level of transnational corporations. Any holistic response to corruption, to combating corruption, must address all sides of the equation. There has traditionally been a huge problem with countries internally fostering corruption through bad governance. However, that also is related to an environment that enables the thriving of corruption nationally, and that environment is supported or facilitated by external actors many times, whether they are transnational corporations or other countries that are engaged in development cooperation. Their obligations also need to be factored in. At the same time, I would say that countries do have an international obligation to support each other, whether through mutual legal assistance, whether through other mechanisms, but particularly capacity building and technical assistance and sharing of information. One cannot, as has been pointed out, take glory in being the least corrupt internally, but also being the most financially secret country, because sharing of information is with developing countries is absolutely essential to combating corruption. You can't be secret in sharing information and take glory in the fact that there's less corruption internally. So those would be my messages to conclude. Thank you.
Thank you very much, Dr. Kanade. Now, please, Madame Bölscher.
Thank you very much. Yeah, my conclusions are that it's highly important to have a clear language about the consequences of corruption regarding human rights violations, regarding the support of violent conflicts, of gender-based violence, and all the issues Mr. Kanade has just mentioned. So I think it's important to work more on the nexus between human rights and anti-corruption, and to say each corruption case has a victim. It is not a victimless activity. And to figure out how we as the anti-corruption community can better make use of the human rights tools and vice versa, to have a very strong focus on gender, with the example on sextortion, gender-based corruption. So because this is sexualized violence, and it's important to have a clear response to these issues. Then to work on the protection of whistleblowers. I think so they are very important actors, activists for our anti-corruption work. And then to work more on the positive narrative of anti-corruption work, because I mean, sometimes within our, let's say, our business as a corporation agency, so it's difficult to convince our colleagues to work on anti-corruption, because they are always saying, okay, but in this politically sensitive context, it's not possible to even mention the corruption issue. So then to try to work on, let's say, on transparency, on prevention of corruption, to make sure that it's possible, even in fragile states or in a conflictive context, to use do no harm and to be able to work on anti-corruption. And then what is our main duty, and I think that this is absolutely, it's very important, really to try to integrate anti-corruption in each project, and to keep working on anti-corruption commissions, etc., but to have this dual approach, and not to forget the political level as a support for the international cooperation. Thank you very much.
Thank you very much, Madame Bölscher, for your comments. Please, Madame Pickering, the floor is yours.
Thank you. And in these concluding remarks, I would again like to thank the organizers and UNITAR and ROLAC specifically for enabling us to share our views, opinions, our national positions, and also national examples with such a big audience. It is indeed a fantastic platform. Thank you very much. In our fight against corruption, and especially corruption that eats away, as all means of corruption does, it eats away at the social fabric of a nation. It eats away from the resources necessary to build infrastructure, to build much needed schools, hospitals, road infrastructure, other infrastructure necessary for development of countries, to alleviate poverty, to reduce the unemployment rate. If we want to fight corruption as a collective in the world, first of all, states need to see to it that their domestic legislation does not become an obstacle in cooperating with other states when corruption cases are brought to the fore, or where corruption has been exposed and needs to be investigated and prosecuted. States also need to position themselves to be able to cooperate with each other in the widest measure possible, as is provided for in the Convention Against Corruption. And also states need to pay particular attention to the issues of ethics and integrity. Ethics and integrity in all sectors and at all levels of institutions, of businesses operating within its territory, and also within the political sphere. Another very important one is the independence of the judiciary. It is critically important that the independence of the judiciary is not compromised at any stage, because once that happens, you have lost 50% of the fight against corruption. Strengthen civil society, open the doors for civil society to be able to be heard, to be able to be active, and to be able to influence processes. I've already mentioned the freedom of press. So in a country where even the basic human rights of people is protected, promoted, and being able to be fulfilled, there the state and the people will have a better opportunity to combat and fight corruption. However, at an international level, it is our joint and collective responsibility to ensure that we assist each other, that developed countries and developing countries work together. It is necessary for us to recognize the right to development. It is necessary for us to also recognize that transnational corporations and the power that they have should be controlled in a better manner as it is now. And with those concluding remarks, I wish everyone success. And I also look forward to engage with others and on other platforms in the future and to discuss multilateralism and the value thereof in the fight against corruption. Thank you.
Thank you very much, Gladys, for your final remarks. Now it's my pleasure to share with you, please, Daniel, a video message from our ED, Executive Director of UNITAR, Mr. Nikhil Seth, for the launch of the e-learning courses. Please, Daniel.
Ladies and gentlemen, on behalf of UNITAR, it is my great pleasure to launch 4 new versions of the e-learning courses developed in partnership with the Rule of Law and Anti-Corruption Center, ROLAC. This conference is an opportunity to stress the importance of mainstreaming knowledge as a powerful lever for transforming the lives of individuals and societies. In a time when people can access, manage, and evaluate information virtually, instantaneously, learning opportunities must change accordingly. Information and communication technologies play an important role to access, manage, and evaluate data and develop new understandings. the e-learning courses on anti-corruption and sustainable development, and the use of technologies for combating corruption, available in English and now in Arabic, as well as the course on anti-corruption and human rights, developed in English and now in Spanish, are tools envisaged to contribute to these efforts. We warmly invite you to join these courses. I take this opportunity to reiterate our deep appreciation to ROLAC for our fruitful partnership. I wish you, dear participants, all the best in your efforts to combat corruption. And learning is the starting point to see how we can tackle the scourge of corruption using multiple means, multiple tools, and multi-stakeholder engagement. Thank you very much.
Thank you, Daniel, for sharing the video. So we are quite excited of launching these new versions of the e-learning courses on anti-corruption and sustainable development. This was first developed in English. It has as features sign language. Before, please. Sign language and audio narrative. It's also now available in Arabic. Then we developed the e-learning course on anti-corruption and sustainable and human rights. It's available now in Spanish. And finally, we have developed together with ROLAC the e-learning course on the use of technologies for combating corruption. The first iteration is running now, and it's also in Arabic. We warmly welcome, invite you all to visit our UNITAR webpage to learn about the upcoming iterations of these e-learning courses. Ladies and gentlemen, it has been a pleasure to share. With you these 3 panels, part of this conference during today's. Next week, we will be contacting those participants who joined us during this time, and we will be explaining how to access to their respective certificates. We will also be sharing with them the videos of the conference, in total 6 hours. We truly appreciate that you have joined us. If you have ever taken one of these courses, I'm the person behind the emails, so it's a pleasure to meet you. And I take this opportunity to express my appreciation to the distinguished panelists for this fruitful discussion. Of course, to our partner, ROLAC, to Dr. Yasser here, and to our team at UNITAR, Madame Beisanour Alada, who is also part of the team that works on anti-corruption, Mr. Israel Ledesma, who is here with us behind the scenes. And thank you so much, Daniel Nazarov, for joining us and helping with the video. We wish you all the best in your endeavors, and this conference is finishing now. Thank you so much on behalf of UNITAR.
Thank you very much, and congratulations.
Thank you.
Thank you. Well done.
Thank you.